Good morning, Your Honour. Benjamin Fox, counsel, representing the applicant, Mr. Tucker. Your Honour, the defence is seeking a pre-trial agreement pursuant to Section 590AA of the Code to have certain Crown evidence excluded from the trial. The defence's first submission is that all of the evidence located in the search warrant related to Unit B52 shall be excluded from the trial, including 110 grams of heroin powder and the cardboard box of train-spotting memorabilia. Your Honour, the defence submits that you must utilise the public policy discretion available to you to not admit the evidence. This was because the evidence was unlawfully obtained by the police officers involved, directly contradicting certain provisions of the Police Powers and Responsibilities Act. Firstly, Section 140, Section 4 of the Act enforces that the application for a search warrant must be made to a Supreme Court judge if, when entering and searching the place, it is intended to do anything that may cause structural damage to a building. Here, the police officer applied to a magistrate, not a Supreme Court judge, telling them of the plan to remove an internal wall. However, the search was conducted and an internal supporting wall was completely destroyed, something which is undoubtedly likely to cause structural damage to the property, therefore in direct contradiction with this provision. Secondly, the police officers also failed to abide by Section 158, subsection 2 of the Police Powers and Responsibilities Act, which enforces that police officers must leave a copy of a search warrant at the premises in a conspicuous location if the owner or occupant of the premises is not there. As Mr. Tucker left the premises before the police engaged the search, they could not have given him a copy of the warrant. However, there is absolutely no apparent reason why a copy could not have been left at the premises before the officers left. They acted recklessly and did not care about procedure. Therefore, the defence would like to argue that this information was illegally obtained and shall be excluded from trial. Although the evidence was likely illegally obtained, it is not for that reason alone inadmissible. The key principles of Bunny and Cross must be present and the competing public interests must be weighed against each other, with the public interest here being convicting one individual or encouraging unfair and unjust conduct by those whose very job it is to enforce the law. When applying Bunny and Cross to this case, we can see that the unlawfulness of the evidence was not created by mistake. The police officer may have not known that they could not have applied for this search warrant to a magistrate. However, the magistrate judge cannot be given the same leniency. Nevertheless, the police officers simply failing to leave a copy of the warrant cannot be ruled as a mistake. The law could have been easily complied with here, and it just simply wasn't. The lack of procedural care in this case is very similar to that of Day and Animal, where the court ruled in favour of prevailing for public policy. And I highly urge you to make a similar decision here. As stated in Ireland by Barwick CJ, convictions obtained by the aid of unlawful evidence may be obtained at too high a price. Admitting the evidence obtained from this search warrant would be undermining the legal structure of use your discretion not to acquit all of the evidence in this trial based on public policy. The defence's second submission is that at a minimum, the cardboard box of train-spotting DVDs and memorabilia at a minimum should be acquitted based on relevance. The fundamental rule of governing the admissibility of evidence is that it must be relevant. The certain evidence is not relevant in these circumstances as defined in Goldsmith and Sandilands, as it does not rationally affect the assessment of the probability that elements of charges for both trafficking and possessing of heroin under sections 5 and 9 of the Drugs Misuse Act have been established. The police considered the train-spotting memorabilia circumstantial evidence of Tucker's connection to heroin use and distribution. Yet as directed in Goldsmith and Sandilands, relevant evidence is qualified by other rules such as practicality and justifiability. Trainspotting is a globally popular, well-renowned film involving drug use, one of many. Regardless of the heroin found in the premises, being a fan of a comedy drama film cannot practically be seen as a rationally proof that a person has committed the act of trafficking or is in possession of heroin. Therefore, the collateral damage of possession relating to the film does not satisfy the requirements of relevance and should be ruled as inadmissible evidence. Unless there is anything further, Your Honour, these are the applicant's submissions.